Hello, hello, hello. This is Attorney Mike Gravel. I'm coming to you from an undisclosed location, and I already did 2 streams today, and I still haven't begun to cover the SovCit madness that occurred just today. So I've got 3 more that everybody sent to me. We're going to start off with a quick one with Judge King. Everybody sent it to me, and for good reason. It's a good reason why everybody sent everyone to me. I saw Knucklehead SovCit on my first stream today, but later when he actually appeared, I couldn't do it. I was busy. So I'm going to use Lone Wolf's stream for that. And I'm going to borrow that one. Shout out to Lone Wolf. And then I've got one with one of my favorite judges and from Team Skeptic. My boy, Team Skeptic, comes through. So they're also good. I just thought I'll just mash them all together. I know it's an odd time, but we've got more coming in Gauthier's room too. I'm warning you right now. So I'm going to try to keep up. God bless the SovCits. They keep me in constant content. Constant content. Well, let me see here. Let's do this thing, shall we? Let's give it a let's stamp this thing.
Yeah.
You don't look like Wilma Turner. What's your name, sir? Oh, there she is. Miss Turner, your matter's been adjourned to March 18th at 8:30, okay?
Okay.
Have a good day.
Thank you.
Sorry, Wilma. Wilma's not the SovCit. I backed up a little bit too far. I'm on the road. I've got constraints, people.
Sir, in Wayne County Jail, what's your name?
Here we go.
Say your name.
Say your name, sir.
For me,
Yeah.
the beneficiary of the state. I'm here today for the state.
What's your name, sir? I don't know who the beneficiary is.
Excuse me?
What is your name?
I'm coming to appear as the beneficiary of the state, Your Honor.
Okay, forget all that. What did your mom call you? What's she name?
I love it.
I have no idea who you are, sir.
Beneficiary, sir.
Okay, well, you're gonna sit there until I figure out who you are.
I'm not under that jurisdiction to consent to the name, Your Honor. That's appearing under your jurisdiction.
Your case is then, because I'm looking for Mr. Pollard. If you're not Mr. Pollard, then you're not here, and a warrant for your arrest, and you can sit in jail till you cry for all I care.
That's fine, Your Honor, but that's
Deputy, you can remove him. He's not here.
he's not here today because he doesn't exist.
Bye-bye.
Okay, bye.
The all
Have a nice
caps,
day.
the all caps entity.
I'm talking to you. Goodbye.
Well played, Judge. Well played. I absolutely love it. All right, and for even more good fun, let's go to the other grumpy one. We'll finish with Webster. I haven't seen that. All right, let me see here. We're gonna stop that. Then I got to find. All right, we'll go to Team Skeptic's video.
And believe me when I say this, you have never heard a judge go off on a sovereign shithead like you're about to hear today. So let's begin.
All right, appearances for the People versus Frank Mishaw Jr. Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not, you know how it works.
I did a video on this judge about a week ago, and he was a big fan favorite. And that was just an unrepresented guy who was painful. But he's already a huge fan favorite. I think that was his first time on the channel. This is even better.
You're on side.
Are you representing at the desk, representing yourself?
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not offended. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try.
Good luck.
Mr. Michaud is a sovereign citizen and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
I really wish more judges were like Judge Oakley. He gets down to business, and you can find a picture of him next to the word no nonsense in the dictionary. Now, as this video progresses, it's gonna get crazier and crazier right up until the end.
If I may, I have advised Mr. Michaud that the courts receive objections all the time, or rule objections that are preserved on the record. If he has,
He can appeal me. I'll let you build whatever record you want to build, Mr. Michaud.
Are we on the record?
Yes.
Are you on your oath to the
Appeal
Constitution?
me,
Hold on,
loser.
are you picking him up? That's one of the reasons I want you up here, is there's a microphone here.
I'll speak loud.
Are you picking him up? Yes. Go ahead.
Are you honoring your oath to the Constitution today?
Pardon me?
Are you honoring your oath to the Constitution? You have an oath to.
I didn't swear an oath to the Constitution.
You haven't.
I took an oath that said I would follow the Constitution.
To not uphold the Constitution?
Yes, follow the Constitution.
So you are upholding an oath to the Constitution?
Yes.
Thank you. I accept your oath. Thank you. Okay? Now I have.
Sir, get your ass in the chair or leave and I'll issue a bench warrant. You're not running the courtroom. I am. If you want to have an exam today, get your ass in the chair. That's the way it works.
I reserve all my rights.
I would have nothing less.
He's so
Now, are
good.
you representing yourself today?
I'm presenting myself.
That's not what I asked you. Are you representing yourself, or is this gentleman going to be your lawyer for today's proceeding?
I will be presenting myself today.
may I-
All right, so that's a no. You don't want him to represent you?
No, for the record, he's not my lawyer. I don't have an attorney. I present myself.
Okay.
Judge, what I recommended to Mr. Michaud is that he has a jurisdictional argument that he wants to make. And that, pending Your Honor's ruling on that jurisdictional issue, I have prepared to conduct a preliminary exam.
Okay.
And could be, available if he wanted to.
Okay.
Ask me to do that at the
Okay.
correct time.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney for the record.
Well, I don't need any more evidence to suggest that his daily hobby is huffing duster. I mean, why would you even want to represent yourself in a criminal matter when there's a perfectly capable person standing next to you that spent as many years in law school as you spent in the 3rd grade?
I'm fine.
Okay.
So with that being said,
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely
Well-
gonna stay.
That's fine.
so today,
You have a jurisdictional argument you want to make?
what I served notice.
Sir,
on
it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a.
Yes or
multiple-
no?
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your
Okay,
jurisdictional
so
argument?
I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of
District
Michigan?
courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that,
I work
Criminal
under the authority of
or-
the state of Michigan.
what is it, under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is
in
not
order-
admiralty,
What is
and
it?
it's not common law.
Which
It's
one?
statutory.
Okay, so it's statutory, that is what, civil?
No,
So what is it? For the
my
record, I need to
jurisdiction
have
is
that on-
both civil.
I can't defend myself unless I have it on the record.
Well, technically, you shouldn't be defending yourself if you don't know the difference between common law, maritime law, and statutory law.
Is it,
My
it's
jurisdiction.
only two,
Sure, shut up. If you ask me a question, I can't answer while you're talking. My jurisdiction is both civil
He
and
is.
criminal as provided by the statutes of the state of Michigan.
okay, so today, under which one is?
This is a
legal?
criminal case.
Okay, right, so is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other, it don't say statute.
All right, then you can appeal my
Constitution.
ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record.
Yes,
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
there must be what?
An injured party.
Yeah, it's the
A
people of the
corpus
state of
electi.
Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement, I have a right to see a sworn statement saying I injured someone,
There's a complaint in the file.
sworn complaint, signed, or
You want to see it?
affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so
You said you wanted a sworn complaint.
from an injured party, who have I injured for the record?
The state of Michigan
How can I
are
injure the
bringing the
state?
charges.
How can I injure the
Sir,
state?
sit down. Sit
I prefer to stand,
down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat, wow,
You're probably going to hear more than one.
I see.
Do you though? Because all I see is a judge who's tired of dealing with a dick flute, and a dick flute is about to do some jail time because he won't sit down and shut up.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge, the people are prepared to move forward. Just as a quick preliminary matter, would request a mutual order of sequestration with an exception for the
So-
OIC.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay, all right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
She's a witness. She is a
witness. Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you, so I'm asking you to state your name. Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object, what I'm supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100.
Nice.
Can we all just take a moment to leave a comment of appreciation for judges like Judge Oakley, who are experts in helping the fuck arounders find out?
Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of
Bless you.
probable cause conference. And I don't know how we're here at a preliminary exam when I did not waive any right to waive a probable cause.
This is a preliminary exam.
This is, okay, so right here it
This is the
says,
probable cause hearing.
it says, it's
All right,
two- it
stop,
says-
stop. Right now, the question on the table is, you've objected to admittance of that document. I want to know what your legal
I
objection
also-
is.
I'm also objecting.
What is your legal objection?
To not waiving my probable cause hearing.
Denied. That's admitted.
Under what
I don't have anything to say except good job, Judge.
grounds am I denied not?
Because
have
you
my
didn't
due
give me a
process?
valid objection.
I object.
You can't just object. You got to explain with the valid
I
objection to the
object
evidence.
that we are having a preliminary exam when I haven't had a probable cause hearing and that I did not.
They're the same thing,
It's
Mr.
it's
Michelle.
still, on this. it
Mr.
doesn't-
Michelle,
it
they're the
doesn't-
same thing.
But it's still, I have a right to a probable cause. Am I right or wrong?
Sure, try.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference. And today is a different date that says a preliminary.
Have you
exam.
ever had a grilled
If it
cheese?
was different,
Have you ever had a grilled cheese?
if it was different, why would it have two?
Have you
separate
ever had a
columns?
grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not gonna let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th, and then again on December 20th. I have disclosed, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable
fine.
cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they
I
are.
know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not gonna talk over him.
Right.
And I'm not gonna play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you gotta be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felon. Do you have any questions based on that?
At what point did I waive it?
We're literally dealing with a living brain donor. If you would just listen to what the judge is saying, you would understand a probable cause conference is nothing more than a meeting where a conversation would take place. Now, a probable cause hearing, which is what you're bitching about being forced to waive, is actually occurring today. So you haven't waived shit. I swear. They should give court orders to people like you to carry a plan around everywhere you go, just so you can make up for the oxygen you're stealing from the rest of us.
Because if it's a hearing. or
You
a conference,
didn't
right,
waive it.
so I
There's
have-
nothing
so
to
do
hold.
I have a right to have a probable cause conference?
No,
What?
you can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There-
And in order
There's
to
no
prepare,
preparing for a probable cause
It's-
conference.
it's-
It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe.
I love that. You want a PCC? There's your PCC. The state says they have no offer. That's it. That's what happens all the time.
Crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he gets to prove his case? Or do you want to waive? That's the other option. You can waive the preliminary exam and we'll take the case directly to circuit court level 2 weeks down the road for an arraignment on information, which I would describe as another pretrial on a felony, where you and the prosecutor can discuss the case, see if there are any offers. That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to.
He can appeal them.
As you've already said, at circuit court. So if he wants to sort of move forward on that defense alone, that, you know, the waiver does not preclude him from
Not at all.
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to that burden, he also maintains the right to, you know, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as
with counsel.
I knew, you were represented by counsel.
Okay, so now you know, and I served the court notices. And I want like to.
First
address my
notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested.
Criminal
the
what?
Bid
Hold on,
bond.
hold on.
I
What?
requested the bid bond, the performance bond. I have the affidavit.
There is no bond.
There are bonds. This is
Okay,
you said it's criminal.
listen. You can't tell me something and then just disagree with me
Well,
and think,
okay,
listen to me, sir. I am not going to let you interrupt me.
No, you just interrupt me.
I'm in charge. I get to do shit you don't get to do. It's part of the black robe, okay? That's just the way it works. My courtroom, I get to decide how it's run.
Now that is how a judge should run their courtroom.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone
I
here
don't-
has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so.
I'm not addressing any of that crap you
Can
got in
you-
front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have
It's on the record. Order a transcript. I'm not signing anything for you.
okay. Also, I want to also address that. I sent a affidavit of fee schedule for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great,
you haven't-
then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you
Okay.
said that.
Right, and
Move on.
you haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't
am not
recognize
a
any of
United
that.
States citizen. I am
Stop,
actually
hold on,
identified.
stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't
Under
recognize
what-
that.
Under what law could you represent, or you can use, tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does
Can you
mean, hold
prove
on.
it?
It should mean something
Can you
because,
prove it? Please prove
can I
it.
prove what?
Prove that I am I am not the that I am the artificial person.
I can prove you're Frank
I have
Michaud.
full faith and credit.
I can
I
prove.
have, okay, so.
Hold on. You've
Are
asked
you-
me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here.
And I.
You
actually
proved
told
it
you
for
threatening
me.
You threatening me.
But if you're not you, the threat means nothing.
It doesn't mean nothing.
Well, if it means nothing, then why are you complying with his baseless orders? Maybe because deep down, you know exactly how wrong you are and exactly how right he is.
But
Okay.
you're still threatening me and you're using it under color of law.
Okay, listen.
And plus
Listen
you
to
have,
me. Mr.
you
Michaud,
you have.
I've
multiple
wasted
officers.
too much time with you. Yes or
Okay.
no?
So.
Sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
Well, I guess this is the point where delusions and reality
Love it.
meet up in the backyard to bare knuckle brawl with this idiot's freedom on the line. In one corner, we have delusions, which are great for manifesting unicorns with rainbow farts. And in the other corner, we have reality, which is great for manifesting jail time for sovereign citizens. And reality wins every time. Now, this is pretty much the end of the video, but the judge had a few more notable things to say.
I object to that. That's
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
On the color of law.
I can give you more than 30 days. John, ask the wife to come in so he can see his property go to his wife. Ma'am, would you accept some personal property from your husband, please?
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me and, I don't mind that, but I just can't let him try to run things.
Yeah. no,
Especially when I got 3 or 4 more exams to do.
Right.
The internet is the worst thing in the world for these guys.
I tried to tell him,
It don't play
the
here.
court is going to deny your objection. Let's allow this to move forward. He might have been able to win this.
And that's the
case.
worst part about all these
Yeah.
cases, right?
Yeah.
Because sometimes they've got a chance if they just,
We had a good
Ron
argument,
right?
Yeah.
Got a constitutional right to remain silent, just can't do it.
You can't fix stupid.
All right, guys, this is the actual end of the video, but don't worry.
All right. That was absolutely fantastic. Let me do this here. So that was so good. Everybody sent it to me. I just want to make sure I wasn't muted. Everybody sent it to me. Why do we have live with StreamYard? What is that showing on my thing? That's weird. Okay. I've got issues midstream. I'm on the road. I don't know why I've got this StreamYard issue going on. Did I not pay them or something? I would. I don't know how. This is making me crazy. All right. Well, we'll deal with it. We'll deal with it. StreamYard, if you need a couple bucks, get a hold of me. It's not an issue. I don't want your crap on my stream. All right. Now let's go. Now we're going to go to Judge Webster. I'm taking this one from Lone Wolf. I saw this knucklehead this morning. I was looking for sovereign citizen DeBoos. This guy shows up. Then I had a hearing and I had other stuff to attend to. He got set over for a couple hours and I was busy when it happened. So here it is. Let me figure it out here now.
All right, we will go on the record now in the 13th Judicial District, the District Court of Greenwood County, Kansas. This is case number 2023 TR3 00060, State of Kansas versus Isaiah S. Curvin. This is a continuance of the hearing called earlier on the 9 o'clock docket. It is now 1:36 p.m. this February 5th, 2024. Coming on for a special.
If you want to see this first time up, I can't remember what I called it. It's 2 streams back. So if somebody knows, put it in the chat. Whatever I called that stream.
Special setting. Now then, Jill Gillette, County Attorney, appears for the state, and the defendant, Isaiah Kervin, appears in person and pro se. This is the pretrial hearing. The trial is set for jury Wednesday and Thursday of this week, February 7 and 8. There is 1 count of operating a motor vehicle without a valid license. Now, that seems to the court to be you either had a license or you didn't. Of course, the burden would be on the state to show there was no license, but Mr. Kervin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before that about the jurisdiction. I was challenging jurisdiction. I had a question about that.
Okay.
I wanted to know the cause and nature of what's bringing the suit against you. I really didn't understand.
All right. Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws.
Oh, come on. Just refer to the Schoolhouse Rock like Gothard does.
At some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the people of the state of Kansas that pass the laws through their elected representatives. And they also pass laws to have judges, and I'm one of those judges that presides over these type of cases. They also pass the law that you can't have a jury trial for this type of offense. And so that's the authority, that's the nature of it. It's a traffic case, but it's also designated a criminal case, a B misdemeanor. So does that help you with your question, sir, or is there something else we need to address?
Well, yes, I have another question. When you say it's been a criminal, would that it gives the court 2 ways? The Sixth Amendment actually gives the court 2 ways to do it. They can do it through either common law or is it colorable maritime admiralty law? Which one am I want to be tried under the jurisdiction?
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But under the Constitution, it grants you only 2, and it has 2 criminal matters. One has to be common law, the other has to be the maritime admiralty.
Ms. Gillette, do you wish to be heard in response? I'm sorry, I didn't mean to cut you out.
Judge, this is basically kind of more of a statutory violation. This defendant, when you enter into the state of Kansas, you consent to the laws of Kansas when you drive upon the highways. The interstate compact between all of the states, that are members of the interstate compact for traffic infractions means that when you consent to the laws of your state, or you drive upon or travel upon the roads of Kansas, Oklahoma, any of the states that are part of the compact, you consent to those laws when you enter into that state. So with the interstate compact, he would be consenting to the laws of the state of Kansas the moment he drives across the border. That law becomes effectual upon you, and it's your responsibility. It's akin as when you have a concealed carry. In Kansas, and you have your concealed carry, it's your responsibility to know which receiving reciprocative of your concealed carry permit. If that state isn't reciprocative, then you cannot do it within that state. So when you become a licensed driver, or you have a license, or you become a driver and you're driving, then you are consenting to the laws of that state that you are traveling within. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well, that's
Therefore,
because I'm just asking questions right now.
if he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
Ms. Gillette, we just had this exact issue on not filing a demand for jury trial in a Butler County case right before the lunch hour. Mr. Patterson presented
We did.
19 Canap Second 982.
You can find it on Law
State of
Talk with Mike.
Kansas versus Gardner L. Jones III.
I was there for the whole deal.
Jones raised two issues on appeal: whether the district court abused its discretion by denying his request for jury trial, and whether the district court erred in denying his motion for setting an appeal bond. Well, I have not had time to read that case over the lunch hour, which began at 1 o'clock today because we ran so late this morning. But Mr. Patterson, as an office of the court, informs me that in a case like this, even though the statute of Kansas is very clear that you are to put your demand for jury trial in writing, the case law says you don't have to because of your constitutional right.
I haven't had time to research it or read it, Judge. I don't have any kind of written request or motions, and I would have to take time to also read the case.
Sure.
And see if it's distinguished, if there's different issues. But he's wanting to argue jurisdiction, dismissal motions, and all kinds of motions. There's nothing before the court in writing for me to respond to. I don't know what he's going to say. So one of our other pro se individuals had written several motions. Most were very lacking, but at least I had something to respond to. In this case, under the laws and Constitution of Kansas, you submit when you come into our jurisdiction. Therefore, when he traveled into Kansas and operated a motor vehicle, he consented to the laws and jurisdiction of Kansas. And I would say that we have jurisdiction, and that lack of venue and jurisdiction is denied, should be denied.
I had a question about that because when you say that I consent, is there like a form? Was that like that? What would that be under? That would be civil. Would that be
Sir,
like a?
you,
Would that be
you
the
can,
criminal matter?
you consented by your conduct of going on to a road that is a state of Kansas highway and a,
So which jurisdiction was that would be under? Like, would that be like maritime, like as a like a
sir,
contract?
I've answered that question to you. And you got on the road and you consented to driving on the road, and therefore you did consent to the
understand that.
laws associated with driving. So I am going to hold you to the law in this
I understand that.
particular case. Now,
what I'm understanding when you say like when you said the cause of nature, and but that's why I was not understanding still about that because you said the cause of nature, and then I asked.
sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them in writing, and you need to have them, sir, listen to me, please. You need to have them in writing. You need to have them filed with the court. You need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings. Where you come in and you just start.
I'm in Cuba.
Saying things.
I have a question.
Things that you may have picked up here or there on the internet or by other people. I don't know where you get some of this stuff, but it is very common for people, certain individuals, to come in and start repeating some of this stuff that so far I haven't heard anything that has merit. These arguments of, well, you're either maritime or you're common law. That's not going to carry weight with me. You're going to have to give me something that tells me I have to follow those arguments, because I think you're misstating the law. So by now you should have had all your motions on file. We're ready.
Maybe misunderstood what I was
please
asking.
don't interrupt to me.
I still had a question.
Sir,
when you're done.
stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to represent, sir, stop interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing, and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law. And if you don't have the benefit of knowing the law, you're going to be disadvantaged.
Well, before I move forward, I had questions before I move forward. That's why I was asking to understand it. I was trying to understand this.
Well, I can't aid you in the unauthorized practice of law. I cannot.
No, I'm not asking. I'm not asking for legal advice. I'm asking for your legal intent. What do you intend to be trying me with jurisdiction? That's why I'm asking if it's under which one. And you said it's a criminal matter. If it's criminal,
Sir,
there's someone's been hurt. So if there's someone's been hurt, I have the right to cross-examine.
I have answered your question legally, and you keep trying to give me limited illegal choices, and I'm not going to do that.
Under the Sixth Amendment, I have the right to know. Under the Sixth Amendment, I have the right to know what jury I'm going to be tried against, and you have the duty to tell me. I don't think you're going to be violating your oath to office if you did that.
I've answered those questions, sir. We need to move on. I've made it clear to you, it's a couple of hearings now that you're being tried in the District Court of Greenwood County, Kansas, under the laws of the state of Kansas. And we're not going to keep running in circles on this.
That is not.
You know this, and I know this, and I feel like you're just kind of.
No, what I'm asking, so the court only, the Constitution only grants the court under when it comes to criminal under two matters, and that's why I asked you: is it civil? Is it civil or is it criminal? What you said is criminal, so it's not civil, right?
Sir, you can reserve your right for appeal, but I have ruled. Now, what's your next question or your next point of view. And I need to have you back here. Bring your camera back so I can see you.
Your phone froze. I didn't hear what you said. Your phone froze. It froze.
I don't know if my phone froze or your deal.
Oh, mine. Yeah, my phone froze. You cut out for a second.
Okay, so do you want an attorney? I'll ask you that again.
Before I get to that, I still have to find out. I have the 6th Amendment right to know. If I ask, I have the right to know. I'm not asking for legal advice. I'm asking for your legal intent.
Do you want a jury trial and do you want a lawyer? Those are the two things.
Before I get to that, I have to understand what jurisdiction I'm under, so I can
Meanwhile, I think Jill Gillette has reached the end of the internet.
rightfully, so I can know how to defend myself.
Okay,
now.
you don't like my ruling.
You don't. So I have to. So are you telling me I have to get a lawyer to understand? For the record,
Yeah,
you
you
have to get
do.
a lawyer to find out what I'm going to be tried against.
Yes.
Is that just some type of
That's pretty clear.
secret jurisdiction that I shouldn't know
Okay.
about?
Okay, sir, here's the deal. You're either, I'm not gonna play games with you.
I'm asking.
I
have the right to defend
understand the
myself.
sovereign citizen
Yes.
position that you take.
I'm not claiming. I didn't say anything about sovereign anything, ma'am. I'm asking.
You're
Have
sure
the right to
making
defend
their
myself.
arguments. You're sure
Under my 6th Amendment right to know. I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer, and I'm like before I even go to trial, I like to know what jurisdiction I'm falling up under, and you're telling me I have to find in order to find out I have to get a lawyer. So you're telling me for the record, the defendant has to get a lawyer because there's only some way only lawyers understand what jurisdiction or what I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the 6th Amendment. Do you not?
Okay, now it's your turn to stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. We're not going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. When I'm asking you, like, because you saying it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
If there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get me?
I'm not arguing about the court. I'm trying to understand.
I cannot educate you and train you.
I'm not asking for educate.
If you want to sir, you know there's a person that's going to try to type out this transcript. And if you keep talking over me, do you know what chaos you're going to cause for that transcriptionist? We have to take turns talking. I've answered your question repeatedly. Let's move on to the next question. Or the next point. You don't have any motions I can rule on because you don't have anything in the file. So are you going to hire an attorney, apply for court appointed, or continue on your waiver?
So if you're gonna try one, is there someone that was hurt to make a criminal matter? I'd like to know who it was.
Are you going to hire an attorney, apply for court appointed, or continue to waive your right and represent yourself? Keeping in mind, sir, if you waive your right to an attorney, you will be held to the same standards as a defendant with an attorney. You will be held to the same standards as the attorney. You need to know the same rules, procedures, and laws. So can you not understand what I'm saying?
Yeah, I mean, if I want a lawyer, if I want a lawyer, I'm not moving forward because I'm not understanding where we're still going under here. Where you're telling me like it's on the criminal matter. If it's on the criminal, if it makes a criminal matter, that means it has to be like some injured party. Where is injured party at?
I'm going to order that you appear at the courthouse. Where are you parked right now?
I'm in Texas.
You do know your trial is Wednesday and you have to physically be present in the courthouse. It is not a Zoom.
Before we get to trial, I'm trying to figure out the jurisdiction. You said we went over to what the jurisdiction is.
Well, if you don't want to submit to the Kansas jurisdiction for your live trial on Wednesday, I can get you a warrant and you can be brought before the court.
That's I'm appearing in person right now. I'm doing my duty to appear, but you're not
We're
telling
not
me.
having a Zoom jury trial.
They're not telling me. You're not telling me which you're not even telling me what the nature of the cause. You're not telling me. You're not even telling me if it's common law. If it's common law, then you telling me that it's a criminal. If it's criminal, then there should be an inter party. I'm asking where's the inter party? Can you bring the inter party forward?
I am going to, Missy, do you know where Miss Gillette went?
I don't, Judge. I'm assuming she lost signal.
So, are you not going to tell me this record date? You do have the right to know.
You want to try
Excuse
to,
me, Your Honor.
do you want to try to see if you can find her for me, Missy?
I think when she gets signal, she'll be back.
Okay, well, we're going to be in recess till Miss Gillette gets her signal and gets back here, because I'm not going to do anything without both parties present. So we're going to go into recess.
Sorry, Judge, my phone screwed up.
Well, apparently the defendants did too, so I'm gonna give him a few minutes to see if he comes back.
Everything went out and I couldn't get back on at all.
There he is. All right. We are back on the record in the 13th Judicial District, the District Court of Greenwood County, Kansas. Case 2023 TR 300060. State of Kansas versus Isaiah S. Curvin. Parties as before. Mr. Curvin, you are set for jury trial.
But before we even get to trial, man, you still haven't answered my questions. But I still want to know the cause of nature of the matter.
Sir, I'm going to find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before we
All
get to jury
right,
trial. You're just
okay.
setting it.
You are now found in contempt. We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand, sir? Any questions about?
I don't. No, I still have questions that was never answered.
I'm not your attorney, sir. I'm your judge.
Yeah, I know you're not my attorney. I'm asking you, Judge. What is your I'm asking for legal advice. I asked you what was your legal intent. You still haven't told me what you're legal intent. I asked you what was the nature and cause of this.
My legal intent is to conduct a jury trial on you Wednesday with the jury.
And what was the nature and cause of this whole before all that? What was
The
your nature and cause?
nature of this charge is that you were allegedly operating a motor vehicle without a license in Greenwood County, Kansas, November 9th, 2023. That's the nature. Now,
and you said this, and I asked.
We're not doing this.
I said a question. So when I asked you what jurisdiction, the Constitution grants the courts the two jurisdictions, which one is common law, and the other one is maritime admiralty law. You said it's neither one of them.
Sir, you better go back to law school, because I don't think you got the education you need to represent yourself. You either need to go back to law school or go to law school or get an attorney, sir, because you don't understand that which you're speaking of. So be ready to go. And if you're not here and ready to go, Wednesday, I will issue a warrant for your arrest.
Your Honor, I still have a question. You still haven't answered my question before you dismiss. I asked you which law.
Sir, I am not
under the Sixth Amendment, right? Under the Sixth Amendment, you have the
okay, I'm gonna fine you. I'm only gonna fine you $50 for that first contempt.
$50 for what?
For continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me what.
I'm going to object. It's been asked and answered. It's been ruled on, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request It may be a trial to the bench under the case law. So therefore, the State v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case to Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we don't waste a jury's time and have a bench trial on Wednesday. And move forward in the case.
Mr. Kervin, do you want a jury trial or a bench trial?
I want a jury trial.
Understand, I'm not gonna prejudge, but I'll strike that, that wouldn't be appropriate. Let's see, do we have tomorrow open? Let's see, we've got a 9 o'clock docket. What do we have going on, tomorrow afternoon, Missy?
We have first appearances and I haven't looked at them yet. And then,
Okay, and then we have 3:30.
yeah, we have a couple at 3:30 and then we have a 4 o'clock case.
Ms. Gillette, can I continue this for further pretrial hearing with the live hearing, defendant present tomorrow at, what do you have, can you fit me in at what, 2:30, Missy? Do you have time then? Pick me a time. Give me about a half an hour tomorrow that you can fit me
I
in.
think our 11 o'clock went off. Let me.
I was going to say
Are you saying I
11 o'clock is the perfect time for the state judge.
Well, but I've got to
So you have
give
to be
Mr.
for
Kervin,
tomorrow?
I've
got a
got to give, sir, please quit interrupting. This is not a free for all. Ms. Gillette, we've got to give him time to drive up from Texas.
Yeah.
Well, if he doesn't have a license, he can't drive. We have to give him time to find someone who can drive him up here or give him time for a plane ticket or however he wants to get here.
1 o'clock p.m. from 1 to 1:30. Then we can start the first appearance docket at 1:30.
Sounds good. Okay. Sir, this is going to be a live pretrial hearing tomorrow at 1 p.m. You must be
I cannot
present.
make it tomorrow, ma'am. I'm in Texas. That's what I was trying to tell you from before.
Well, there's,
You told me you said Wednesday at first, and now you're saying tomorrow.
well, your jury trial is Wednesday. Your pretrial is continued to 1 p.m. tomorrow. There is no law that says I have to give you a Zoom hearing. I try to do that as a courtesy. In
I
most
could do the
cases,
Zoom, but I wouldn't be able to drive because this like where I'm at, like I'm already like right here by San Antonio. It's like about a 14-hour drive. Like even if I like drove right now, I would still wouldn't make it to like or like probably 2, and I would like drive like this like 32, 14. That's like half a day driving. Now I don't have nobody to drive like that. You know, man. Like that's why like
if you don't have a license,
Yeah, things you should have thought of before you started saying stupid stuff in court.
you better not be driving because then that'll be another violation of the law. But that's my order. Be here at 1 o'clock tomorrow, live and in person. If you're not here, then
Find a plane.
most likely a warrant would issue for your arrest and we'd go from there.
Well, I'm telling you, if I wouldn't make it, what's my other option? If I'm already in Texas, not to, 'cause that's hours away. You know, it's like about 4 different states.
Well, sir, you came to Kansas, you violated the laws allegedly in Kansas, and you've taken up a lot of the court and council's time. So.
Well, I was told the
you're-
officer said he told me I can take care of it from Texas. I would have to come back to Kansas when I got the rest of the
I
ticket.
have always told you that the trial would be live. Don't be pulling that on
No,
me.
no, not you. I'm talking about the officer when I got the ticket when I first got it. I let him know like I was just coming through Kansas. Like you don't live here. He said she said normally it's stupid do video and stuff because it's like different state.
Normally it is, but I'm ordering that you be here in person tomorrow at 1 o'clock. And anything further, Ms. Gillette?
Nothing at this time.
Hold on, my phone cut out. Hold on. So,
Mr. Kervin,
say that again, ma'am.
any motions you want to take up tomorrow at the pretrial, you better have them filed by 5 o'clock tonight with copies served on the prosecutor, or I'm not going to entertain them tomorrow. You've had a long time to get those on file and you haven't done it. And I'm through with repeating myself over and over. So at this time, you owe the court $50 for contempt. We'll address that tomorrow as well. Okay, we'll begin recess.
I have a question before we go. When you said like how to file the motions and everything, did you receive my special appearance motion or anything like that?
Nope. No, sir.
You hadn't received it from last time?
Nope.
I filed that before.
No, sir. I don't know what you're doing with them, but we're not getting them here.
I was told that you had received them through email, or I sent the email
Okay,
to I sent it a
sir.
few times. Not like that was the only way.
Yeah, you can't email the judge.
If you can't figure out how to do it on your own, then you need an attorney. And I have told you repeatedly that if you cannot afford an attorney, you can apply, and I will appoint one.
They told me they had received them before. That's why I was understanding. Like now you say you never received them, but you say you received them before, like the first time.
Look at Jill.
The first time we appeared, and then I actually I haven't received them. I haven't called.
Just because you keep repeating something doesn't mean you're going to get a different result.
No, I haven't repeated. I'm asking like they never received it, but they told me they did. That's just
You keep saying the things over and over, thinking like you're going to get a different result, and the answer is going to be the same every time.
Okay. You have a good day, y'all.
Thank you, sir. We are.
Ah, well, there you have it. That was delicious. That was delicious. I had myself a little nap. I woke up, and then everybody had sent me all three of those. Everybody, thank you to all who sent it to me, and for good reason. 3 SovCits going down hard, and this was after I had already done 2 streams. So yeah, I don't know. I can't keep up this pace. I can't. But today I could, so I got it done. Thank you all for coming out. I appreciate it. I know it's the middle of the night for a lot of people, but I guess it's the middle of the night for people always. You know, it's round, it's spherical. Yes, I'm taking the controversial stance that the Earth is not flat. I am. You guys caught me. All right, good times. I apparently have to settle up with StreamYard. I didn't know what that is. It's all hell's breaking loose over here. That's all right. We'll figure it all out. Thanks for coming out. I will probably try, if possible. There's not 1 but 2 SovCits potentially in front of Gauthier tomorrow morning. So there you have it. All right. I will see you all soon.